Welcome to the Luxembourg Fundcast.
Great to be here.
Today we're diving deep into something absolutely crucial in Luxembourg finance and banking law. Legal opinions.
Absolutely essential, yes. They pop up everywhere in transactions.
We've got some solid ground to cover this, drawing from a recent LFC UP date analysis, bits of the civil code, the law on commercial companies.
And quite a few key CSSF circulars, too. Things like the ones on STS securitizations, MyCar for crypto assets.
Right, and those newer door updates for digital resilience, plus the instant payments regulation info, and even the CSSF's thinking on AI.
It's a busy landscape.
It really is. So our mission today is, well, to clarify what these opinions are all about, especially that difference between a capacity opinion and a full one.
A very common point of confusion.
Exactly. We want to get into the what, why, who, where, and how for you, particularly if you're working in law or finance here in Luxembourg.
Okay, let's get started. These opinions, fundamentally, are about risk assessment. They're formal conclusions on Luxembourg legal points in a deal.
So not guarantees, right? More like professional judgments.
Precisely. As the LFC UP date points out, they're based on the law and the documents provided. The goal is really to flag potential legal issues and confirm the key assumptions everyone's relying on.
And given Luxembourg's role as this major financial center,
With complex, often cross-border deals, that legal certainty is just paramount. There isn't one single law saying you must have an opinion for everything, but market practice. It's deeply embedded, it's due diligence, it's risk management.
Okay, so let's start with the first type. What exactly is a capacity legal opinion?
Right. A capacity opinion, sometimes called a corporate authority opinion, it's foundational. Its main job is confirming key legal facts about the Luxembourg company involved in the deal.
What kind of facts are we talking about?
Well, several things. First, does the company actually exist legally? Is it a valid SA or an SERL or whatever form it claims to be?
Okay, basic existence.
Basic existence. Second, does it have the power, the legal ability, what we call capacité de jouissance, to even enter into this type of transaction? We check its articles of association, the objet social, and general company law.
So is this deal something the company is allowed to do?
Exactly. Third, did the company actually authorize this specific deal internally? That's the capacité d'exercice. Did the board or managers, maybe even the shareholders, pass the necessary resolutions?
Or the internal green light?
The internal green light. And finally, fourth, were the documents signed by people who actually had the authority to bind the company? Due execution.
So essentially it's confirming. Is this company real? Is it allowed to do this? Did it decide to do this properly? And did the right people sign?
You've got it. It tells the other parties that the Luxembourg entity is a legitimate actor, capable and authorized for this specific transaction.
Why is that so critical? What's the real purpose, the why behind needing all that confirmed?
The why really boils down to fundamental assurance for everyone else in the deal. Lenders, counterparties, they need to know the entity they're dealing with is legitimate.
Avoids dealing with a phantom company, I suppose.
Precisely. And it confirms the deal aligns with the company's own rules and articles. It also verifies the internal decision-making was correct. No one wants a deal potentially invalidated later because the proper board approvals weren't obtained.
Right. That could be disastrous.
Absolutely. And knowing the signatories have actual authority means the contract is properly binding on the company. Without these basic checks, the whole legal foundation of the transaction could be shaky.
Makes sense. Okay, who are the main players involved here? The who?
Sure. You've got the issuer, which has to be a Luxembourg qualified law firm or lawyer, an avocat.
Okay.
Then you have the addressees. These are the parties relying on the opinion, typically the lenders, agents, maybe a security trustee, other counterparties.
The ones who need the assurance.
Exactly. And finally, the subject, the Luxembourg company whose capacity is being checked.
And where do we typically see these capacity opinions being used? What kind of deals? The where?
Oh, they're very common. You'll see them in standard loan agreements, credit facilities where a Lux company is the borrower or guarantor.
Okay.
Security agreements like pledges or charges granted by a Luxembourg entity. Also M&A deals involving Lux companies, debt or equity issuances.
So pretty much any significant transaction.
Generally, yes. Anytime a Luxembourg entity takes on substantial legal or financial obligations, the other side will usually want that capacity opinion for basic comfort.
Right. And how does it actually happen? What's the process, the how?
The process starts with the law firm doing a deep dive into the company's corporate documents.
Like what specifically?
The up-to-date articles of association, the statutes, coordinates, the shareholder register, minutes from relevant board or manager meetings, maybe shareholder meetings too.
Checking the internal records.
Correct. Plus, they'll do searches at the Luxembourg Trade and Companies Register, the RCS, to verify public information existence, registered directors, that sort of thing.
Independent verification.
Then the opinion itself will always have assumptions and qualifications. Lawyers can't guarantee everything, so they state what they've assumed and what the limits are.
Standard practice.
Standard practice. And finally, the formal opinion document is issued, signed, and dated, usually right as the deal closes.
You mentioned key documents. Could you list the really essential ones for a capacity opinion and maybe touch on the typical clauses inside?
Sure. The essentials usually are those coordinated articles, statuts coordinate, a fresh RCS extract, the shareholder register, board manager registers, and minutes showing the approvals, the specific resolutions for the deal, and specimen signatures for the signers.
Got it. And the clauses.
You'll always see one on corporate existence, confirming it's a legal entity under Luxembourg law based on the articles and RCS. That links back to basic company law principles.
Okay.
Then corporate power, or capacité de jouissance, checking the deal, fits within the company's stated purpose. It's objet social. Due authorization, or capacité de sexis, confirming the internal approvals, the resolutions, were done correctly according to law and the articles.
Right.
Due execution, confirming the signers were properly authorized, looking at resolutions and specimen signatures. That often ties into Article 116 of the company law about representation.
And sometimes good standing.
Yes, sometimes. Based on the RCS excerpt, confirming no public notice of winding up or bankruptcy, it's a snapshot based on public records.
Okay. Is there much negotiation around these capacity opinions? And what drives the cost?
Generally, less negotiation than with full opinions. But parties might discuss, say, exactly which documents are covered, the precise wording of assumptions, maybe the as-of date for the information.
Minor tweaks usually.
Often, yes.
Yeah.
Cost factors. Well, how many Lux entities are involved? How complex are their structures? Are the records easy to get? And how fast is it needed? Urgency always adds pressure.
And the detailed document review takes time, obviously.
Absolutely. That meticulous review is key for a reliable opinion, and it's a big part of the cost.
That gives a really solid picture of capacity opinions. Now let's shift gears to full legal opinions. What's the extra layer here, the expanded why?
Okay, so a full opinion includes everything in a capacity opinion, but then it goes further. It looks beyond just the entity's ability to act and examines the legal status of the transaction documents themselves.
So the agreements, the contracts.
Exactly. The core aim is to confirm the legality, validity, binding effect, and crucially, the enforceability of those documents under Luxembourg law.
Much broader scope.
Much broader. It often tackles whether the deal conflicts with Luxembourg law generally, or the company's articles, or even sometimes other agreements the company has signed.
That sounds complex.
It can be. It might also cover the validity of choosing a foreign law to govern the contract or submitting to foreign courts, and any necessary filings or consents in Luxembourg.
What about security?
Yes. In secured deals, a full opinion often covers whether the security, like a pledge, has been properly created and perfected under Luxembourg law. So it's about giving much more comprehensive comfort on the legal robustness of the whole deal structure.
Okay, so the who involved the lawyers, the company, the addressees is largely the same, but the where, the types of deals, might be different or more complex.
That's a good way to put it. The core parties are similar, though sometimes reliance might extend further, maybe to rating agencies and capital markets deals. But the where definitely shifts towards more complex scenarios.
Such as?
Think syndicated loans with many banks, structured finance, bond issues, securitizations like those STS ones we mentioned.
Right.
Secured lending where Luxembourg assets are collateral, deals specifically governed by Luxembourg law, and definitely cross-border transactions where you have potential conflicts of laws to analyze.
Got it. And I assume that how the process is also more involved for a full opinion.
Definitely. The document review is much wider. You're not just looking at the company's corporate records, but also the main finance agreements, security documents, intercreditor agreements, guarantees, basically all the relevant deal paperwork.
A lot more reading.
A lot more reading and substantive legal analysis. You're testing those documents against Luxembourg law, validity, enforceability, etc.
Which means the assumptions and qualifications might be more detailed too.
Yes, particularly around enforceability, which always has standard limitations, and any interactions with foreign law and cross-border deals. There's usually more negotiation on the exact wording because the stakes are higher and the analysis is deeper. But like capacity opinions, they're typically issued right at closing.
So what are the key extra clauses we'd expect to see in a full opinion, beyond the capacity points?
Okay, the big one is the opinion on legality, validity, and binding effect. This confirms the agreements are properly formed and create binding obligations under Luxembourg law, often referencing civil code articles like 1108 on contract formation and 1134 on agreements having the force of law.
The court confirmation.
The core confirmation. But it's always followed by enforceability qualifications. No opinion guarantees enforceability, absolutely. It will mention standard limits like bankruptcy laws, equitable principles, public policy, or public good faith, bonne foi, procedural rules, time limits.
The standard caveats.
The standard caveats, exactly. Then you'll often find a no conflict with laws opinion confirming the deal doesn't breach Luxembourg law or the company's articles. A no conflict with other agreements clause is trickier, often heavily qualified, as the lawyers rely on lists the company provides.
Understandable.
If there's a foreign governing law, you might get a choice of law opinion, basically saying Luxembourg courts will generally respect that choice, citing rules like the Roma regulation.
Okay.
Similarly, a submission to jurisdiction opinion might confirm the agreement to use foreign courts is valid under rules like Brussels I recast.
Practical points for cross-border deals.
Very practical. Also, a no need for filings opinion, identifying any necessary procedural steps in Luxembourg. And as mentioned, if there's security, detailed opinions on security perfection under Luxembourg law, referencing things like the financial collateral law of 2005.
It definitely sounds like more negotiation points could arise with a full opinion. What are the typical sticking points, and how does that impact the cost?
Yes, negotiation can be more extensive. Common areas are the exact scope of the enforceability opinion, the wording of qualifications, how broad the no conflict opinion is, materiality thresholds used, and definitely the specifics of security perfection opinions.
Lots to discuss.
Lots to discuss. And that naturally leads to higher costs compared to a capacity opinion. It's the complexity, the sheer volume of documents, maybe foreign law aspects needing consideration, and just more in-depth research and analysis required.
Okay, to really cement this, let's do a quick compare and contrast. What are the absolute core distinctions between capacity and full opinions that people should remember?
Absolutely. The core difference is scope and depth. Capacity is about the entity. Is it real? Can it act? Did it authorize this? Full opinion covers the entity and the transaction. Are the agreements themselves legally sound, binding, enforceable under Luxembourg law?
Entity versus entity plus transaction.
Exactly. So the assurance level differs. Capacity gives baseline comfort on the actor. Full gives that plus comfort on the legal integrity of the deal itself.
And the practical choice depends on
Risk appetite and complexity. Simpler deal, maybe foreign law governed, capacity might be enough. Complex, high value, secured, or Luxembourg law governed, you'll almost certainly need a full opinion for that comprehensive legal assurance. It's often a non-negotiable condition precedent in those cases.
That's a very clear distinction, thanks. Now let's look underneath all this. What are the foundational Luxembourg legal principles these opinions rest on?
They're deeply rooted in the civil code and the law on commercial companies. In the Civil Code, Article 1108 is key. It lists the 4 requirements for a valid contract: consent, capacity, a defined object, and a lawful cause.
Capacity being the main focus for capacity opinions.
Correct. And Article 1123 states the general principle of capacity to contract. For companies, that capacity is tied to their corporate purpose, objet social, and the powers of their governing bodies. Capacity opinions verify there's no legal block.
And for full opinions,
Article 1134.1 is crucial, the pacta sunt servanda principle, that lawfully formed agreements are binding like law between the parties. That underpins the whole binding effect and enforceability analysis in full opinions.
makes sense. And the law on commercial companies, how does that fit in?
It provides the whole corporate framework. First, legal personality Article 100-3 now confirms companies are distinct legal entities. That's fundamental for them to own things, contract, sue, the very basis confirmed in capacity opinions.
The ability to be a party.
Precisely. Then Article 116 deals with representation, how companies act through their boards or managers, and how third parties rely on the public register. This supports the opinions on due authorization and due execution. The law also defines the objet social, limiting what the company can do, which is checked in capacity opinions. And it sets the rules for corporate approvals, board resolutions, shareholder votes, which the due authorization opinion confirms were followed.
So the opinions are really applying these core legal building blocks to the specific transaction.
Exactly. They bridge the gap between general legal principles and the specific facts of the deal.
Now, things don't stand still, especially in finance regulation. What about the CSSF's role and recent or upcoming changes? How do they impact these opinions?
Well, the CSSF doesn't have a specific legal opinion act, but its regulations definitely shape practice. Take Circular 19719 on STS securitizations. It explicitly requires legal opinions on STS compliance to be available. That sets a tone.
A requirement for opinions in certain regulated areas.
Yes, and look at Circular 25890 on MyCar. It has very detailed requirements for legal opinions on crypto asset classifications, even providing a template that focus on competence, independence, structure. It could influence opinions more broadly.
Interesting. What about more recent changes?
Okay, lots happening. The Instant Payments Regulation implementation via the law for April 2025 that could impact opinions for payment service providers on things like fund safeguarding or new penalty regimes.
Compliance points for PSPs.
Right. And DORA, the Digital Operational Resilience Act, is huge. It's fully live in January 2025. The CSSF is active with related circulars like 2580, 882, 883, dealing with ICT risk, third-party providers, outsourcing.
How does DORA affect opinions?
Full opinions might increasingly need to touch on DORA compliance, especially reviewing critical ICT contracts mentioned in Article 30. We might see changes in reps and warranties in loan docs related to operational resilience.
Something for finance lawyers to watch closely.
Definitely. Other things. The move to T+1 settlement, while mainly operational, could ripple into securities finance docs. The CSSF's focus on AI is still developing, probably minimal impact on standard opinions now, but potentially down the line for due diligence, perhaps.
And crypto.
Yes, the travel rule guidelines for crypto transfers, implemented by Circular 25879, will impact opinions for firms handling those. The overall trend. Regulations are getting more specific, more complex, demanding more adaptable opinions, maybe with more nuanced qualifications.
It certainly seems like legal opinions are indispensable tools, but also ones that need to constantly adapt. Any final takeaways for our listeners as we wrap up?
I think the key takeaway is just how vital these opinions are for managing legal risk in Luxembourg finance. Understanding that core difference between capacity and full opinions is crucial.
Knowing what level of assurance you're getting.
Exactly. And appreciating how they're grounded in fundamental Luxembourg law, the civil code, the company law, but also how they're constantly being shaped by this evolving regulatory environment, especially around digital finance and resilience like DORA and MyCar.
The increasing specificity is a clear trend.
It really is. It suggests we'll continue to see demands for more detailed, rigorous opinions. So staying informed is key for any professional in this space.
Absolutely. Well, this has been a really insightful deep dive into a complex but critical area. For everyone listening, if you want to explore further, definitely check out those CSSF circulars. And the laws we mentioned, they're available on Ligilux and the CSSF website.
The primary sources are always the best place to go.
Indeed. Thank you so much for joining us on the Luxembourg Fundcast. If you found this useful, please do hit subscribe and like. It helps us keep bringing you insights into Luxembourg's financial world.
The Luxembourg Fundcast.